Chair.
I call Andrew Bailey.
Mr Chair, it's a pleasure again to be talking on the Immigration Amendment Bill number 2. Slightly disappointing to hear the opposition talking about this bill, because this bill is really important in terms of protecting those migrants and those immigrants that come to New Zealand and provide an important contribution to this economy. In my own electorate, I see a number of them who come and support the horticultural industry in Franklin, and they play a very important part. On the other end of this, we need to also make sure we put in place proper controls so that the Immigration Office can do its job. And this bill is particularly focused on legitimately enhancing controls and procedures, particularly focusing on screening, monitoring, and also powers of inspection. We want to make sure that those migrants, those immigrants that come here are protected and that they are not exploited. And a number of the speakers have spoken about that concern and those issues that have been occurring, and we want to make sure we stamp out. Probably the most important thing of this bill is that it introduces quite severe penalties, namely a jail sentence up to 7 years or a fine of $100,000 or both. These penalties reflect the seriousness that this government is putting on this issue, and we are simply not going to tolerate illegal treatment of our migrant workers. Now, I want to turn my mind to 3 clauses of the bill. The first is Clause 42, which my colleague from the Transport and Industrial Relations Committee just spoke on previously. Under this bill, Clause 42 is actually widened by Section 42(2)(1), whereby the definition now states that a person commits an offence if any information on the application form for a visa or an entry permission was fraudulent, forged or false, the 3 Fs, or misleading, or omitted irrelevant information, whether or not the person holding the resident class visa or the entry permission provided the information or not. Now, in my view, the first part of that change is absolutely understandable. The second element really gets to the heart of the issue with someone else filing on behalf of the resident or the person getting the entry permit some false documentation and therefore allowing a travesty to occur. And I think that's a particularly relevant part of the clause, to make sure that all information provided to the Immigration Office is actually timely and accurate and full. With regard to the second clause I want to focus on, it's Clause 61. And this clarifies the definition of specified employment as it relates to the powers to enter and search an employer's premises. The new definition now gives the immigration officer powers of entry for search for employees on an employer's premises, and this is the new bit, if they have good cause to suspect. If they have good cause to suspect a specified employee is committing an offence. Personally, I think that's essential that the immigration officer can undertake their duties, but it's also vital that the Immigration Office also undertakes that search in a proper manner. The third part, or clause I want to just turn my mind to, is Clause 80, subsection 3A. This addresses the obligations of the employer in relation to the hiring of unlawful employees. So you can see on one side, and under Clause 61, we've talked about the unlawful employees. On the other side, we're now talking about the employer's obligations. And this new amendment replaces clause or section 351 of the Act and states that an employer is committing an offence if he or she knows that an employee is not entitled to do any particular work if within a period of 12 months prior to that period the employer is informed of the fact by the Immigration Office, whether or not that employee is holding a temporary entry visa or otherwise. Now again, this clause is really dealing with the issue of employers hiring.
I call Tracy Martin.
Kia ora, Mr Chair. Thank you.